I'd like to tell you a little bit about mediation. Mediation is assisted negotiation. It's a process by which a third party, a mediator, assists the parties to a dispute in an effort to find a resolution. Mediation exists in many contexts, and mediators have a very wide variety of styles, but generally, mediation is consensual between the parties, it is informal, it results in binding agreements, and it is private. Mediation takes place in a variety of contexts and in disputes both big and small. Mediation is frequently used in neighborhood disputes, and it's also used in disputes between warring nations. Many mediators are lawyers, but generally there are no licensure or job requirements to be a mediator. All good lawyers know that negotiation is an essential skill in representing clients, and that the vast majority of disputes are resolved by agreement of the parties. Courthouse statistics generally show that somewhere between 0.5 and 3% of lawsuits actually get tried in court, and most disputes are resolved even before suits are filed. Mediation exists because sometimes the parties to a dispute, with or without lawyers, need help in their negotiations. Good mediators are skilled at exploring the positions and the interests of the parties, and in helping them figure out the best resolution to meet their individual circumstances and needs. A hallmark of mediation is party self-determination. A good mediator does not tell the parties what to do. Instead, she helps them examine their own needs and desires, and then determine a resolution that meets those needs and desires. A good mediator helps the parties find a resolution that might or might not be a type of resolution that could be offered by the court if the case were tried. Mediation is a process, not necessarily a single event. The parties communicate with each other and with the mediator, sometimes together in joint sessions, and sometimes separately in private or in caucus sessions. The goal of mediation is a written agreement that will end the parties' dispute in a manner that meets their needs and their desires. Studies of mediation have demonstrated time and again that parties to a settlement are more satisfied with results reached in mediation than with settlements that they feel are imposed on them, and that the rate of compliance with mediated settlements is higher than with judgments imposed by courts. By its very nature, mediation is consensual and it's informal, so there are few rules that apply. However, Ohio, like most states, has adopted the Uniform Mediation Act. The primary hallmark of the Act is that it provides that mediation communications are privileged and in almost all cases confidential. No person, including the mediator, can be compelled to testify about statements made in mediation, and mediation statements are not the subject of discovery and litigation. Mediation is intended to be a safe place where parties can discuss their disputes, gain greater understanding of their own needs and the needs of their adversaries, and find a resolution to the greatest extent possible that meets those needs.